dealing
before
with.
you go into these issues again, we cannot approach this just like a judicial review of a legislative action. This is what is being attempted here by the Parliament, is to amend the Constitution. So you cannot approach it just like you challenge a statutory provision which is being amended on the touchstone of Part 2. This is a constitutional amendment that is being made.
Indeed.
And that is being done by the Parliament. To what extent can this court intervene or judicially review such a constitutional amendment?
Your Lordship.
What are the grounds on which we will be able to intervene?
Your Lordship, it is
Do you have any cases or any precedents to suggest on this?
Your Lordship,
cases where the Supreme Court had considered the validity of a constitutional amendment. We have a umpteen number of situations where a legislative provision has been challenged, or the constitutional virus has been challenged.
Indeed.
Now we have a situation where the constitution is being amended. Which are the main precedents on the point wherein a constitutional amendment had been subjected to scrutiny by the Supreme Court?
Indeed, Your Lordship, the landmark case of Keshwananda Bhati versus State of Kerala itself, Your Lordship, where it was Honorable Supreme Court mentions the fact that if basic structure doctrine was laid down, if Your Lordship may refer to flat 1 of the compendium provided, Your Lordship, and the Honorable Supreme Court mentions basic structure doctrine.
So it is just the basic structure.
Indeed.
Nothing else, just the basic structure. The court can intervene only when there is an intervention, or rather a change, or rather a kind of a intervention into the basic structure doctrine. That is all. No other means for interfering with the constitutional amendment.
Indeed. Indeed, Your Lordship. Yes, ma'am. Yes, Lordship. Your Lordship, in this Your Lordship, in this particular instance, Article 19(1)(a) has been violated, which in issue number 3, my co-counsel would be dealing in depth and proving the fact that how right to vote is protected under Article 19(1)(a) and how that particular thing is violated. Freedom of speech and expression. It's Article 19(1)(a), freedom of speech and expression. Yes, indeed, Your Lordship, that's been affected of the people's right to cast their vote, which has been affected, which in depth my co-counsel would be dealing in issue number 3. Indeed. Your Lordship, when it comes to right to vote, there have been multiple. Your vote need to be in contract law. We study free consent, Your Lordship. That consent or voting that need to be done, it need to be free from any coercion, undue influence, these things, Your Lordship. And this in detail would be dealt in issue number 3. Apologies, Your Lordship. It is indeed, Your Lordship. It is interfering when it comes to casting of the vote, and Your Lordship, it's essential that the voters be free from any influence in terms of casting of the vote.
What is the influence? Then after the notification of election, you can put your franchise. What is wrong that as per this amendment is concerned?
Your Lordship, there are multiple implications from the fact that, Your Lordship, if one nation, one election is being done, Your Lordship,
Council, it should be precise, because what is wrong with your right to vote? Now it is interfered.
It's not been, Your Lordship, a free will of the candidate of the citizens to cast their vote, Your Lordship.
What is wrong with the free will? You can go and put your vote.
That is what's the summation of the council is the fact that it's not limited to only casting of vote, but the vote is need to be free and fair from any sorts of coercion, influence, and there are multiple influence of the same in the.
Right to vote has not been taken away.
Your Lordship,
you can vote for any candidate in the legislative assembly and another candidate of party for the parliament election. It's your choice. That is not being by the amendment. So how you are applying, sir?
Your Lordship,
Right to vote.
this is what Your Lordship, what the council is contending is the fact that The vote, merely casting of the vote is not essential, but that need to be free from any influence, something which in detail.
Then council, who is influencing you?
Your Lordship, when it's the process of one nation, one election that is being held, which basically, Your Lordship, what happens if there are one nation, one election, there are three manifestos, there are three government being debated. It's all about.
It's a part and parcel of every election.
Your Lordship, that's not the.
And it's also a matter of freedom of the campaign of other political parties because they have fundamental right.
Your Lordship, there are multiple implications for the same, Your Lordship.
So council, you should precise say that what is the nature of right affected. Otherwise, the petition is not maintained because the council is well aware of the jurisprudence of Article 32 under the Constitution.
Even Your Lordship, it's even Your Lordship influence as in Your Lordship what happens like once there is election in the state, the Parliament, the Prime Minister comes, the leader of opposition comes, the matter of the state is being adjudicated. But once this particular thing comes,
you are bringing it down to 19.1.
Indeed.
As my sister would point out, you have to place your contents within the parameters of that fundamental right which you agree stands to be violated.
Indeed.
Now the question is, you have the right to vote. Your right to vote has not been taken away. As my brother was pointing out, your right to choose to which party you should vote is also not been taken away.
Indeed, Your Lordship.
Your choice remains intact. How does this one nation, one election campaign in any way interfere with your rights under Article 19.1? We put this question to you because you are confining to Article 19.1, nothing more.
Your Lordship, one of the, if Your Lordship, the council may redirect.
There would be another question as you are a NGO.
Indeed.
You are an NGO.
Indeed.
How your rights are being affected would be another question altogether.
Indeed.
When we can understand a citizen coming in and saying that my rights under 19.1 has been affected. Well, we would go to the question of August very later. But you are terming it as something that is a violation of 19.1. As my sister points out, you will have to explain it further. So as to place it within the confines of that fundamental right, the challenge.
Indeed. Your Lordship, the council would resubmit the case in PUCL versus Your Lordship, even in this particular Honorable Supreme Court bench, if any of the facets of right to vote is being affected, then the particular petition can be maintainable under Article 32 of the Constitution. If Your Lordship may refer, the paragraph has been highlighted, Your Lordship. If I may read it again for the bench benefit. Your Lordship, the width and amplitude of the right to information about the candidate contesting elections to the Parliament or the state legislature in context to the citizens' right to vote broadly falls for consideration in these writ petition under Article 32 of the Constitution.
Different situation altogether. Does this apply to the facts and circumstances of the case that you are arguing here? No. This was regarding the width and amplitude of the right of information about the candidate. The citizen has the right to know the details of the candidates for whom he is going to vote.
Indeed.
Fair enough. How do you here when you are challenging the constitutional validity of a constitutional amendment?
Your Lordship, that
This doesn't, the PUCL decision doesn't help you in that.
Your Lordship, it
You
basically,
have to look elsewhere so as to substantiate your contention.
Your Lordship, it basically mentions the fact that if any of the postulates of right to vote is being affected, then that particular petition can be entertained under Article 4.
Postulates of right to vote, if it is affected, that would entitle you to a petition for Article 30. Fair enough, we can understand that.
Indeed,
It is
Your
with respect to something arising out of the Representation of People's Act, because that is based on which it is being conducted. You are not on that statute here. You are on a constitutional amendment.
Even Your Lordship, there are multiple precedents to support. Even Your Lordship, when NJAC
Has your rights under the Representation of People's Act been affected in any manner
indeed,
by this constitutional amendment?
apologies, Your Lordship.
Representation of People's Act is a statute
Yes, indeed,
based on which the elections are conducted.
indeed, yes.
Has any of those rights under that statute been affected?
Your Lordship, it's not been amended. Only the Constitution has been amended.
Then one more thing comes to you because here the facilities are more convenient for the voters. You can come and put the vote in a single day. And it's facilitating your right to vote in a better way.
Your Lordship, if
That you can working there because you can go to booth and put all the votes and come back home and you can enjoy other days. Then how can you say that that is restricting your right?
Your Lordship, that is restricting the right in a law in a very broad sense, and the reason why, like, it's a violation of
What
like.
is that broad sense?
If in terms of Lordship, it's like violation of the basic structure is from the essence, like Your Lordship, democracy. There is like during independence, like framing of the constitution, this was heavily debated. Like any of the democratic countries, what is the concept of having a fixed term? That was heavily debated. Multiple countries will find 4 years, 5 years, 6 years. In our present case, it's 5 years, Lordship. There was a reason why 5 years was given. 5 years was given so that the voters have an accountability for the people to know what is the development being done.
So all these explanations are not focusing any jurisprudence of Article 32. I think the Council is well aware of what are the grounds under the Constitution for making a petition under Article 32.
Indeed, yes, and Your Lordship, the jurisprudence of Article 32, if Your Lordship, is the fact that it's not limited. If Your Lordship, if Your Lordship, when it comes to like jurisprudence of Article 32, Your Lordship, it's not merely restricted to fundamental right being violated. In the case of Supreme Court Advocates on Record Association versus Union of India, basically the appointment commission of the judiciary was challenged, Your Lordship. In that particular case, if I may request the court officer to pass this, in this particular case was maintainable. That petition was maintainable under Article 32 of the Constitution itself, Your Lordship. So basically, jurisprudence, it's not by the literal interpretation that in terms of violation of fundamental right, the particular petition need to be entertained under Article 32 of the Constitution. But in this particular case, where the commission was challenged, that was entertained by this Honorable Supreme Court under Article 32 of the Constitution itself, Your Lordship.
So, Counsel, this is with regard to the jurisdiction of the court under Article 26 and 32.
32.
But the basic primary question is for the maintainability of the petition under Article 32, which is the category of right, because that is very clear.
Indeed.
Yeah, under Part 3, that is applicable to every person of India. The word used under Part 3 is person.
Indeed.
Then how far this NGO can access to this right is another question.
Your Lordship, this NGO, is representing the interest of the citizens itself.
Yeah, on a representative capacity.
Indeed.
Yeah.
And henceforth, Your Lordship, when it comes to like how this particular right is being violated, that is mentioned in like issue 3, would be in depth dealt by like in the third issue itself.
Okay.
So fundamentally, Your Lordship, if I may proceed, Your Lordship, there have been 3 issues that have been faced. Firstly, whether that particular one nation, one election is against the basic structure doctrine. Secondly, that whether one nation, one election undermines federalism and democratic principle. Thirdly, whether the rights of the citizens of representation being affected. Your Lordship, first 2 issues the Council would be dealing with and engaging 22 minutes of this court's time. Whereas issue number 3 would be dealt by my co-counsel and she will be taking 19 minutes of this court's time and we reserve 4 minutes for rebuttal. Your Lordship, this basic structure doctrine, one of the component of basic structure doctrine is federalism. Henceforth, the Council has clubbed both the issues when it comes to issue number 1 and 2 and would be arguing collectively, Your Lordship. If Your Lordship may refer to flag 1 of the compendium, that basically mentions like what all the components of basic structure doctrine. That's not been defined in a very exhaustive manner. Like this is what that's left for evolution, interpretation by the courts in the times to come. There are multiple facets here. If I read for the benefit of the court, that the basic structure said to consist of the following things: supremacy of constitution, republic and democratic form of government, secular character of the constitution, separation of power between the legislature and the executive and the judiciary, and federal character of the constitution. What has been violated with this particular one nation, one election is...
Counsel, you are raising the issue of violation of federalism.
And Your Lordship, two things, violation of federalism.
The relevant question is, as per this amendment, Article 172 is reaffirming federalism and the state has given some strong position for they can keep for a maximum 5 years. There is no interference. Then, as per Article 378, the ratification procedure, everything is clear under this amendment act. Then, how can you raise the situation of federalism?
Your Lordship, mainly because of the fact that procedure have been followed to the majority by both the House, 50% ratification. But still, if that is against the basic structure, that could be challenged. And there are 2 broad submissions to prove the fact.
Which is that basic structure?
Your
There are
Lordship,
so many
basic structure doctrine that is laid under the case of Keshwananda Bharti case.
Then
But
which is the basic
two
structure?
submissions,
So
Your
many
Lordship.
things are basic structure.
Firstly,
For
when
example, democracy is a basic structure.
Indeed.
Yeah.
What has been violated is two submissions: democratic form of the government, democracy, and second is federal character. How this particular thing has been violated, Your Lordship, it's very important. The fixed character what the council was contending from the fact that there was a reason why fixed tenure was given, 5 years. And what has happened with this particular thing, the parliament has made it to a midterm election. If Your Lordship may refer to the amended act in the proposition, which is Article 39, Article 83, subclause 4, and 172 subclause 4, which basically mention 172 subclause 4. These two things mentions the fact that once the house has been dissolved, what has happened, the new government that is formed, that will be formed only for the remaining period, which is to say that once a government is formed
Again, there is a possibility for reformation of democracy. There is no any workout.
Your Lordship, that is what happens generally is like if a government falls, the new government that is appointed, that will be appointed for 5 years. But after this amendment, what has happened, if the new government is formed, it will form only for one year.
This is a Article 85 and Article 174 of the Constitution relating to the power of the President and Governor to dissolve any state because of some reason.
Your Lordship, when it comes like dissolving of the house and putting state emergency, there are plethora of like SR Bome or something in terms of like putting like dissolution of the house. They need to prove the fact that the state machinery have failed. And in order to implement, what is the fundamental flaw in this particular thing?
The Constitution never have given any full security for any ministry or any state. There are some provisions for dissolution of the state.
Your-
Can it be considered as
Your
violation of federalism or violation of democracy or violation of basic structure of constitution?
Your Lordship, that particular thing, the government will fall once that government is not there in majority. It cannot fall, even if the government falls, that's sure. But the new government that will come into the process, into power, will be elected for 5 years. And what if it loses its majority? Again, the election will be there.
Mr. Jennings pointing out is that this sanctity that you seem to give to this 5-year period
Indeed.
is not there. The governor or the president can, if the circumstances deem it necessary, intervene and say that enough is enough. So the 5-year period is not something sacrosanct and it is not something that is guaranteed even now as it stands now.
Yeah.
So to say that 5-year period is something that is being tinkered with, hence that affects democracy, doesn't even stand as scrutiny on the basis of the provisions as they stand now. That is what is being pointed out.
Then Article 356 also, another provision, it's not confirming your security.
Your Lordship,
The Constitution
what?
itself is not protected, that's why.
Indeed. Your Lordship, what the contention of the council is that that there could be like premature dissolution before 5 years, but the new government that is formed will be formed for 5 years, Your Lordship. But after this particular act being implemented, that will form only for the remaining period, Your Lordship. And even for the implementation, the grave concern is implementation of one nation, one election, Your Lordship, is the fundamental flaw and the most democratic flaw is the fact that, Your Lordship, right now, multiple state legislative assembly, local bodies are tenure are ending at different intervals. In order to synchronize it, the synchronize can happen only by two factors, Your Lordship. Either we prematurely dissolve the house, that is under Article 356, or we extend 5 years interval in order to synchronize all the election at the union, at the state, and the local election. And the humble submission of the council is both of the powers the parliament doesn't have, even in terms of prematuring dissolution of the house and expansion of the house. Because merely if Your Lordship, if state emergencies be, if Your Lordship may extend the time. So Your Lordship, indeed, it's Your Lordship. So what has been done, Your Lordship, even for putting it premature dissolution under Article 356, that is putting state emergency, it has to prove that the state machinery has failed. But in this particular case, none of the thing has been failed. And Your Lordship, can the parliament, the bigger question is, can the parliament dictate the tenure of the government that is elected by the people? Your Lordship, this is fundamentally against the democratic principles. When we say democracy, it's the rule of the people. If the people have chosen a particular party, how can the parliament dictate the tenure of that particular thing? This is the most fundamental flaw in this one nation, one election.
Is it not the decision of the parliament, is the will of the people?
Indeed not, Your Lordship. Because, Your Lordship, there are multiple, Your Lordship. the people have elected at the union level. That people have not elected them in the state level. It's the people who determine it in your lordship. So what the country in terms of like implementation of this tenure as well, the parliament does not have any power when it comes to like premature dissolution or
The house of the people.
Indeed.
Called the house of the people.
Indeed, yes, your lordship.
So the people have selected their representatives.
Indeed, yes.
They, after running this republic for 75 years, they think that there is a need to streamline the election process. And it's not as if this is being thrust upon the nation or the republic. It is being done by the people's representatives. They want to see to it that there needs to be a synchronization. There is lots of waste and also practical problems when it comes to security and arrangements for this election. They feel that elections, if it's done in a single go, that would be beneficial not only in monetary terms, but also to serve the interests of the democracy. When people's representatives decide so, why should we?
Your lordship, when it comes to like people choosing at the union level, and it's the people who have chosen.
This is also something that is being passed as per the mandates of the constitutional amendments as laid down in the constitution. So it's not as if this is being thrust upon. All those mandates that are necessary for making the constitutional amendments are being met. So what is the need for the court to intervene?
Your lordship, but this honorable court in the case of Keshwan and Abati.
One thing is that it will get an equitable distribution of democratic power. Another and they can rule because there is no concentration of any democratic power within the number of elected person. It's a democratic approach. This amendment to share the constitutional powers for the number of political parties because it is the principle of unity and diversity. There are different national parties are there. They can take over the power and it's a prestigious seating which is provided by the constitution as per the amendment.
Your lordship, if this has been implemented, it will be grave from the fact that your lordship, as your lordship directed, Indiana is a diverse country. Your lordship, your lordship, if your lordship.
Your only contention is that the new election will be only for the remaining period. That's if there is a midterm election, and then after that election, the new legislative assembly will get only the remaining period.
Remaining period.
How it will affect the federalism?
Your lordship, when it comes to like federalism, your lordship, in SR Mumbai versus Union of India, your lordship, when the presidential rule was challenged before this honorable Supreme Court, if your lordship refers to flag 2 of the compendium, your lordship, it mentions that federalism is not merely a political arrangement but essential features of constitution and cannot be altered or destroyed. This has been destroyed, your lordship, that the government is not, because essentially what happens, your lordship, if at state level it falls, it will be the government that will be formed will be 5 years, but after the implementation of this particular constitution, what is being done, the rights like of the state government is being curtailed when they have been.
The same thing happens also, parliament election also. If the parliament is dissolved midway, they will also get only the remaining period.
Indeed, yes, your lordship.
So, what is the distinction? How federalism is affected?
Your lordship, because of the fact that the state won't be giving a level playing field as such, your lordship, where they have to all the synchronizing of elections, and it will have multiple implications, your lordship.
Is it the practical difficulties that you are pointing out, or the constitutional or the legal implications?
Your lordship, both, even in terms of like constitutional
Considerations are gone.
Indeed.
They say that there are some practical benefits. You would say that there are practical problems as well.
Indeed, yes.
Keeping them apart. From the constitutional point of view, what do you think are the implications?
Your
There's no vacuum.
Indeed.
You should understand the situation. This does not envisage a vacuum. If there is a midterm election, elections would be convened and that particular assembly would continue for the rest of the period. So, no legislative vacuum as such.
Thereafter, the people can elect the same government also. After that remaining period.
If your lordship may extend 2 minutes time.
Yeah, in addition to that, the council, if in case of a coalition government, one of the political parties are withdrawn, this will saying happen as per the provision of the constitution.
Your lordship, the main reason what the council said is that 5-year term that was given in order to have the voters the accountability. The problem that is pointed is the fact that if a government falls after 4 years, the new government after the election commission will declare a date after 6 months, parties will come up with manifesto. Your Lordship, what the new government will do for 6 months, ideally what the government would be doing is not to look at any of the welfare schemes, but only fulfilling its desire to come into the government, come into power like after 6 months. Exactly.
This is the process of every administration. When an officer is retiring, another person will come, continue the same job.
Your Lordship, then the fundamental ethos of democracy, Your Lordship, where there won't be any accountability. This will create more chaos when the government is falling like after 4 years. There's absolutely waste of like multiple function as well, when no long-term objective would be fulfilled. Only the desire of coming into power of elections during the next year. That is what the reason, because this particular thing was heavily debated while framing of the constitution, and that is the reason there's a fixed interval, 5 years that was mentioned. 5 years subjected to whether the particular government is there in majority. Indeed, that it is against the principles of federalism. If Your Lordship may refer to flag 6 of the compendium, where Panchi Commission on Central and State Relationship has been looked into. The court highlighted that the importance of preserving the state government in terms of conducting elections. And even, Your Lordship, in this particular incident, what has happened is the fact that even elections at the local level, panchayats and municipalities is taken into account. Whereas this particular thing is a subject matter, Your Lordship, of the state to adjudicate it. It's mentioned.
As far as this proper self-government system is concerned, this amendment is not incorporated. Because it's a matter of concern of state, under the state list. That is not covered under this amendment act.
That's under the second amendment that has been passed. If Your Lordship may refer to the Moot problem. Your Lordship, it's under the second amendment. It synchronizes the election of the municipality and panchayat together with the general elections, Your Lordship.
Is it sustainable under the constitution, because it's a matter of concern of state list?
Indeed, what is the submission of the council? Because it's under entry 5 of the state list itself. What's the council contention? It's the state to adjudicate when it comes to election of the local bodies and of the parliament, Your Lordship. Henceforth, the structure of federalism is also being questioned, Your Lordship. And Your Lordship, there have been just to like sum up my submissions, Your Lordship, there have been multiple things, Your Lordship. There might be cost benefit that there is, Your Lordship, but cost is not something a big thing for the largest democracy, Your Lordship. And even, Your Lordship, the concern of this particular thing would be fact that if this particular thing is being implemented, so there are fundamental flaws in terms of implementation itself. The parliament does not have the power to premature dissolve or extend the tenure in order to synchronize all the elections. Secondly, Your Lordship, when it comes to like elections being held, Your Lordship, what the Lordship, Indiana is a very diverse country. The problem of Kerala won't be the same as of Bihar, Your Lordship. In so much diversity, Your Lordship, if this one nation, one election is affected, because what happens if state have a particular election? The matter of that state concern is being debated. Prime Minister comes, leader of opposition comes. That state matter is being a subject matter of discourse debated. But if this particular thing, one nation, one election is being implemented, what will happen is only the national interest will surpass the state interest. And implementation, Your Lordship, there are 7 countries in the world which implementation one election. Countries like Japan, Sweden, Your Lordship, all these countries are very small. Your Lordship, if we take the example of Indiana, Uttar Pradesh itself, if
there is no restriction for any political party in participation of this election, there is no prohibition. Even a single party consider of more than 10 or 20 members can participate in this election. Then what is the problem?
Your Lordship, the problem is in terms of forming the government. In terms of can the parliament dictate the election at a whole, and there are constitutional difficulties as well, and the implications of the same as well. And even, Your Lordship, this is against the federal structure as well, which the council clearly mentions that a subject matter of state to legislate it, the parliament cannot dictate that particular thing. The parliament cannot dictate the election of the local bodies.
You can sum up and conclude.
Indeed, yes, sir. Indeed, Your Lordship. To sum up, Your Lordship, this one nation, one election is against the structure doctrine that is laid down in the case. Further, it's a violation of the federal structure of the Constitution. So this Honorable Supreme Court may declare one election as unconstitutional. It was an honor arguing before this honorable court. Now, co-counsel would be dealing with issue number 3.
Greetings to the bench. This is Counsel 2 appearing on behalf of the petitioners and will be addressing issue 3 before this honorable court. So if your lordship would permit, then the council would like to proceed with the arguments. Much obliged. Your lordships, in this issue, the council will be addressing that how the rights of the citizens to elect a representative is being violated by this constitutional amendment, that is one nation, one election policy. It can never be compromised for administrative convenience. Here, democracy will always stand on a higher pedestal when we are looking expenses of a state, or if we are looking voter turnouts. Democracy will always be on a pedestal, and it will stand as strong as any foundation of the constitution. Even our preamble imbibes that democracy is inherent, and therefore the council would like to give two broad submissions in this issue. First, that there is a violation of the fundamental rights of the citizens of Indiana, and secondly, also it violates with the principles of free and fair election. So moving,
Which right you are mentioning here?
Article 19(1)(a).
Freedom of speech and expression.
Yes.
Yeah, what is wrong with your freedom of speech and expression?
Yes. So the council would like to begin that the right to elect a representative is the expression of the citizens, an opinion, a will that the citizens are expressing by this.
You can come and you say you have machine and put your own. What is the problem? Then who is preventing you?
Indeed, your lordships, if we see here at the national, state and regional level, all elections.
Whatever it may be, that is a machine provided you to put out. Yeah, you can easily put your vote basically.
Indeed, your lordships, and the council.
What is wrong with your?
The council will be answering that, but for the court's benefit, the council would like to state a landmark judgment by this honorable court, that was Anup Baramwal versus Union of India, which is mentioned in flag 8 of the companion, and you can also read page 14 of the argument note provided, where it clearly stated that right to vote is a choice of a citizen, which is a fundamental right under Article 19(1)(a). The right to vote is a part of citizens' life, as it is their indispensable.
No doubt it is a fundamental.
Indeed.
You don't need any decision.
Indeed.
What is wrong with your right to vote?
Indeed.
Because you have sufficient opportunities, sufficient polling staff, sufficient facilities.
Yes. So,
electronic mechanisms are there. You are well fit for doing your vote. There are security measures. Then what is wrong with the right to vote?
so the council here is stating that Article 326 has to be read along with other fundamental right, that is Article 19(1)(a). Here, the landmark case of UCL versus Union of India, if we look at flag 11.
Freedom of speech and expression means you can do the campaign for any political party, any candidate.
Yes.
No restriction.
Yes, for that the council would like to mention this PUCL versus Union of India, where Justice Venkatramana Reddy, in his concurring opinion, mentioned two postulates for right to vote. First, that there shall be formulation of an opinion that whom they will cast that vote, and secondly, expression.
With regard to right to information and other details of the candidates, there is no prohibition for getting any information with regard to the details of any candidate, because access to information is easy for any authorities in India.
Indeed, but here the postulates regarding right to vote was affirmed by the justice, and that's why the council is stating that here expression of opinion is one thing, and sorry.
You can express your opinion. Why not? That is the vote is your expression.
Vote is an expression, but casting of vote is one thing, but formulation of an opinion that whom they will cast is another thing. Here.
In India itself, in 1952, 57 and 62, simultaneously.
Indeed.
So what happened? What was the difficulty?
It was withheld because there was presidential rule, and because of that the chain got broken, and state interest was taken into consideration. That's why it could not be continued, and it shall not be continued, because here we will overshadow the interest, that is state interest, and regional interest over the national interest. If we see national interest, that is security of the nation, or
So you are undermining the thinking capacity of the
Here we have.
They can identify the issues of national importance. They can identify the issue of state importance. Everything they can identify the issue. They can comprehend it.
Your lordships, if we look at the literacy rate also, it is quite different from one state to another state. If we look at Kerala, literacy rate is quite high. But if you look at Bihar, literacy rate is quite low. And there is a likeliness that they might get influenced, which the council is will mention in the second limb, that is violation of principles of free and fair election. One of the very important component of
Is it a ground for challenging the constitutional value? There is an amendment in the constitution.
Your lordships, here it is violating the rights of the citizen to elect a representative. A very inherent right, that is a fundamental right, is being violated, and it has to be read with principles of free and fair election.
Where it is violated, according to which article you should give the precise answer.
According to Article 19(1)(a), where
Is it in Article 83 or 172 or Article 82A? And which is the article you are opposing? And where is the facility for prohibiting or restricting your right to? Because you are arguing such a way, that's why.
your lordships, Article 83, 172, both will come into consideration, because at one instance, Article 83 talks about Lok Sabha elections and 172 talks about state.
There is no any instance of restricting your right to vote, that's why.
Right to vote is not restricted at all. But here,
You are arguing for right to vote.
prima facie, it is not restricted. But here, an indirect influence is being infused in the minds of the people.
Then influence is available in every election, even in a local authority election. So many people are influencing. You are an educated person. You are not beyond any control of any citizen of India. Even media is also influencing. Can you prevent the media? Can you prevent the printing media? All these things are influencing you as an voter.
But we have to think from the point of view of an average citizen voter who will be voting simultaneously for national, state and regional interests.
Simultaneous voting is more convenient to you because you can put the vote within a single ballot system. You can vote to your home. There is no
It might be
expensiveness on the part of the voter. And then if you are in queue, there is a facility for casting your vote. If you are a disabled person, there is a facility for casting your vote. If you are a blind, there is a facility for casting your vote. Then if you are an aged person, you can put your vote in your home. These are the facilities added in the Representation of People's Act. Then how can I say that it is preventing my right to vote?
Indeed, your lordships, but these are just convenience for one day. But the citizens will be infringing their fundamental right for one day convenience.
As per the Constitution.
Your lordships, according to this one nation, one election policy, here in one day, the citizen will be casting their vote. So, as you're stating that it will be convenient for the citizens.
No, Article 83 and Article 172 is fixing the tenure of the democratic body. It's not diluting the Constitution. Then that is also in favor of the voters, directly or indirectly. How can I argue that that is violating the right of voters?
The term is fixed, as in 5-year term that is now a full term, that is there.
Yeah.
But here, if you see, there's a midterm election that is being introduced, that is being infused. So, for example, after 3 years, a government falls due to any reason, no confidence motion or any reason is there. So, for the remaining 2 period, that is the unexpired term, the government will be elected. And as my co-counsel mentioned, it might take 6 months or for preparing the manifesto and all, and it will be like 1.5 years. The government will be serving the people. But here, the people won't be able to analyze that what aspirations they had with the political party and what aspirations the political party has fulfilled in that remaining span. And again, general elections will
Elected
be.
again, as my brother was pointing out, they will be elected again. They
Indeed.
have the choice, the people have the choice of electing again.
Yes,
The
indeed.
very same group or very same party that had been elected in the midterm elections. They will continue for another 5 years.
So here, they will be
What
re-elected.
happened in Karnataka and Manipur? Because as far as an voter is concerned, there is no any power under the Indian Constitution to restrict the voting process. The only agency which is provided under the Constitution is Chief Election Commission and the President. These are the executive body under the Constitution. How can the voter decide these things?
Sorry, Your Lordships.
No, under the constitution, there is no any provision conferring an order to control these things.
Yes.
Simply, they have the right to vote.
Indeed.
These things are beyond the control of an order. This is a
Indeed.
constitution machinery. India is a country ruled by the constitution. Then it's applicable for every citizen of India. How can an order says that this will be the fixed city and I'm not ready to put out after 6 months or 1 year? And how can you argue like that? And which is the constitutional authority for you? Because there is a constitutional authority like Election Commission and President of India. They are the empowered authority. How you can say is that I want to control these things? You just have right to vote. If they are modifying the election, you just have right to vote. That's all.
Your Lordships, we are not controlling in the matter that you stated, but what we are implying that it might lead to a autocratic government. Here, if you refer flag 13 of the compendium, in that Niti Aayog report was there, where it stated, there was a report that if simultaneous elections are there, there is a 77% likeliness that a similar party will be voted. And here, if a situation is there that there is a one-party rule all over the states, then how can it?
That is okay, but how it affect your right to vote? That is okay.
If
Autonomy, autocratic government, these things are okay. Then how you link with these two things?
so, if the citizen's vote is rendered meaningless because we already know that there will be a government, it's pre-decided because of the simultaneous election, because of the influence being infused, that there will be one party, then the voters, the ability of the voter to vote, that is the.
Concern, how can you say is that because it is dependent upon your percentage of vote?
Sorry,
It's
Your
not
Lordship.
prefixed. It's not prefixed. It is dependent upon your vote. You are choosing the person.
Indeed,
You decide.
the voter is choosing, and it's the people's discretion. But if that discretion is only influenced by the national interest being brought in, the state
Because
interest.
the elections happen simultaneously for the parliament, the state legislature as well as the local government. Does it mean that everybody will go and vote for the same party? They may vote for one party for the parliament election, another party for the assembly. And maybe all these votes are maybe done on the same day, or maybe as far as
Indeed.
panchayats are concerned within 100 days after the other two. So why do you say that it will invariably lead to autocracy?
It might lead to,
There
because
have been situations in our country, in history, where the same party had been ruling for all along for around 60 years.
that is there, and
Democracy remained intact.
yes, that's people's discretion when they are choosing.
As long
But
as the people's discretion is remaining unaffected, can, as my sister was pointing out, beyond going and voting, can the voter come and control or have a say on all other aspects as to how at one point of time the election should be conducted, what should be the terms, etc. Is it something, especially since everything, all of your contentions revolve around 1918? Would all these questions come under 1918?
Your Lordships, when we are considering 1918, we are talking about the will of the citizens, the opinions of the citizens. And in this right to vote, when they are casting their vote, they are choosing the government who will be representing them in the government level. So they are choosing a very inherent part of their lives for that.
Your main argument is getting to the influence of somebody else. It's only a speculation. Because I am an educated person, I'm seeing every news and every pamphlets and all this, everything. It's my choice. Then who is influencing me? It's only a speculation of you. Then how can you argue based on speculation?
Your Lord,
You have to argue based on legal points.
It's your right to vote, or right to choose any party, or right to campaign. Nothing has been interfered with. Only the recognition of election. That is only.
but if we look at the percentage of people who are literate and who are illiterate in our country, we have to consider all aspects. We cannot just consider certain set of people who are educated and who might may be able to differentiate between all these elections, because it is quite different for one state to have some interest, one region to have some interest, and some interest which another state or another region had. And we have to look from the point of view of an average citizen who will be voting for the simultaneous elections here. So we cannot.
Also, for the illiterate category of voters, it's more convenient for them because they can simply put the vote in a single ballot paper and go. Is there any problem for them?
But the vote will have no value because it is reducing.
Why there is no value?
Because it is reducing the value of the citizens' vote here. Because if, as the council stated,
Putting the vote in simultaneous election or in separate election, what is safe? Counting is safe. Process is safe. Representation of the act is safe.
but if that vote is not only in a fair manner, because here, if you look at the principles of free and fair election, first principle is that as stated in flag 9 of the compendium, it is clearly stated that it should be free. It shall be free, and it should not be there should not be any duress, fear, or influence on the minds of the citizens who are voting. So here, this is one contention, and secondly, if we look at the first one is that it shall be free, and here the freeness.
That decision is about bogus voting.
It was in context of it was in context of bogus voting, but it was laid down that when the voter is casting a vote, he shall be or she shall be free from any duress, any sort of influence. But here, if we see here, they are putting the citizens are being put in a situation.
How you can say that you are put under fear and duress?
Because your lordships.
Because the election to the parliament and the state assemblies are simultaneously held. How can you say that you have been put to, or the voters are put to fear and duress?
They are in a situation of duress. They are in a situation of duress because
Already in a situation of duress.
because
And then comes the election. They are already in a situation of duress. Then comes the election, and then they have to vote again.
indeed.
The point is, D comes because now 172, Article 172 deals with duration of state legislation. This is being dictated by a constitutional amendment. Would it be necessary to consult the state legislatures and take their consent before doing that? That is a point that you may be able to argue, which you don't, which you are not arguing. Your contentions are all centered around 1918. That is the problem that you are facing. I'm just giving you an example. The state, the duration as regards state legislature is clearly laid down in 172 as it stands now. This is going to be, have the state legislatures been considered? Is it necessary to have the concurrence of the state legislatures beyond a number before doing that?
It is necessary, and the and according to the Moot clarification, also the consent of the state legislature has been taken, and that's why the due process has been followed.
Take it that ground. Have you taken that ground?
Yes.
Sorry, Your Lordship.
Have you taken that ground? Have you taken that ground?
Like
You
it's
won't say
mentioned.
that it has already been complied.
Yes, because we are not challenging the due process because it has been followed.
It's already been.
It has been complied. So what the council also
The
wants.
council, one of the relevant question is, after complaining Article 368, can you say that there is a violation of federalism? Because 50% is the required mandate as per the constitution. Then how can you say that there is violation of federalism? Because they are complying all the ratification process and
More
other
than
things.
50% have been ratified, already ratified.
It has been ratified, but another 50%, they have
It's
not.
not mentioned under the constitution. How the government can the constitution?
But your lordships, here 50% has not given consent, and even
It's
if
considered, that is why the constitutional amendment has passed in December 17th, 2024. That is also amended by the president.
So the will of the people
Your
is in
lordships,
favor.
if you can
And you should
provide
understand
2
that the
minutes.
will of the people is in favor of this amendment. Because the parliament has passed it, more than 50% ratified. So that means that's the will of the people. Is it true?
But your lordships, here 50% ratification is there. 50% ratification is there, but you also need to look that what was ratified accordance with the basic structure doctrine, and which was not there, and that's why the petitioners have approached this honorable court.
Structure doctrine, as you mentioned here, is federalism, isn't it?
Indeed, and also principles of free and fair election.
Then it's a concern of election commission. Then it is a statute of the government under the Representation of People's Act to conduct a free and fair election. It's not a basic step from Indian Constitution.
Your
It's
Lordship,
purely an administrative mechanism entrusted by the Constitution,
but
according to the provisions of the Representation of People's Act.
But if we see, this principle of free and fair election is a very part of basic structured doctrine as it was laid down in the case of Indira Gandhi versus Raj Narain, where it was clearly held that free and fair election is an inherent part of democracy of the basic.
Also helping you, what is role of the free and fair election? Is there any bias or is there any...
There is bias, there is influence on the minds of people.
Yeah.
Who are-
If Star is standing as a candidate in simultaneous election or a normal election, then are you a fan? When you are putting the vote in same title, then who is influencing you?
That are the tactics of campaigners, and we cannot control everything as such. But
You
here,
don't understand the influence. What is the meaning of influence? What is your interpretation?
influence here, the council is stating that the different interest of a citizen who's staying in a particular state might have different state interest, and national interest will always overshadow the state interest of that citizen. Because right now I will be concerned regarding war, what is happening with the war with other nations, and not with maybe water disputes, and that will overshadow that. And that's why that sort of influence might affect the minds of the people. Because if national interest is there, people might choose go for the national interest and vote.
So how can you argue that in the world of information technology, that people are getting access to information even in developed countries, even in international countries? Then how do you restrict all these things, even the news and the information are communicated through the social media? Then every voting based on FIR case. Why not? The people are daily seeing the news regarding this case. How can you prevent that? How can you prevent the influence of an outer world of information technology? You have access to information within second, you will get it.
That happens in every voting, and either it's separate election or it's simultaneous, or it will be simultaneous election. But if we are going for simultaneous election, then the very expression will be curtailed. If we see the model code of conduct, that is
You mentioned about containment and the freedom of the citizens. Did you contemplate in terms of bringing in Article 14 of the arbitrary states of Article 14 in a situation where the curtailment of this tenure of the state legislatures, for example, it might be tenure curtailed maybe for the extent of 60% with respect to certain states, which is a substantial curtailment. In respect to certain other assemblies, it could be maybe 20%. So there is an inequality in this, which may attract the arbitrariness facet of Article 40, in addition to Article 19, 1A that you are hammering. Have you considered in that? Have you thought in that as well?
Your Lordships, if we consider Article 19 and
We are not
as
on 19 at all, because
as
we
we-
had enough of Article 19.
okay,
We are
as
just looking at Article rope rate,
indeed as
Article 40,
so
and not equality, the arbitrariness facet of Article 40. Is there anything arbitrary in the entire exercise whereby we see a possibility? We are just trying to help you, since you have no other than Article 19 1A.
Your Lordships, the council
Is
was
there a possibility of bringing in Article 40 by virtue of the arbitrariness of Article 40, where we may be faced with a situation where the state assemblies tenure would be contained in one situation to 60%, taken away. In the other case, maybe 30%. So substantial difference. Is in that arbitrariness? We
your
can argue, but we are just thinking of various possibilities.
So, Your Lordships, if we consider the golden, yes, it is arbitrary, and if we consider the golden triangle also that was stated in Maneka Gandhi versus Union of India. So, when Article 14, 19, and 21 will always, if one is violated, then it will violate other articles also. So, that is there, and that's why, if Your Lordship, the council has answered that thing. So, the council would like to make one statement regarding the model code of conduct. So here the model code of conduct was introduced so that these parties don't influence the minds of the citizens, because during the election processes they introduced many arrangements or many projects so that the voters cast their vote. So the main intention was that the citizens are not being influenced. But here, if we introduce the one nation, one election policy, this is striking in the very intention of introducing MCC, that is influence, because people might go for a similar party and it might lead to an autocratic government, and that's the council is pleading. Also, here stability will not be followed, because citizens, if we see, always vote for a stable government, a government that is stable. But here, stability will be broken, because if we see, if the government falls after 3 years, for 2 years they have to re-elect the government for that unexpired term.
If we look at the way in which Indian elections have been going, the people vote for parliament with a specific mindset, and they vote differently when it comes to the state assembly.
Indeed.
And they would vote altogether differently when it comes to the local government elections. So to say that people would be thinking symmetrically with respect to all the three, at least from our practical experience, is not correct. Even though it doesn't have the legal elements to it, but from the practical point of view, that connection doesn't seem to be very applied.
Your Lordship,
And regarding what about 82A4? Will it give the election commission an unbridled power to postpone election to one recent or something?
Your Lordship, 82.
A4.
Indeed not, Your Lordships. That the council is not contending.
Okay, you are not taking that.
Indeed not, Your Lordships. And Your Lordships, the council, as the council was stating, that here it will also be strenuous to the resources of that state as well, because if it is appointed for that remaining period, then the political party might not look at the long-term objectives of that state, but might fulfill their political objectives as well. So it may be strenuous for the resources which is of the state which is already in a lower pedestal. That is, if we consider Bihar or UP, then it will be strenuous for those states as well. So the council would like to conclude by stating the case of Kuldeep Nair versus Union of India, where, if your lordships may refer flag 10 of the compendium, where it clearly stated that for democracy to survive, it is essential that the best available men shall be chosen as people's representative for proper governance of the country. This can be achieved through men of high moral and ethical values who win the elections on a positive note. But in this instance, it is not happening, and hence this policy of one nation, one election is in violation of the people's right to elect a representative. So if your lordship is convinced, then the council would like to move to the prayer. Therefore, in light of the issues raised, arguments advanced, and authorities cited, it is humbly submitted before this Honorable Supreme Court of Indiana, may be pleased to declare that the Constitutional Amendment Acts implementing one nation, one election are unconstitutional and against the doctrine of basic structure. Second, that the acts undermine the basic structure of federalism, that the policy violates the right to elect representative of the citizens of Indiana, and or pass any other order it may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the petitioner shall be duty bound forever, all of which is most humbly and respectfully submitted. It was an honor arguing before this honorable court.
Council seeks permission to proceed before the rest. Yes, Your Lordship, I shall be the single speaker for this response. May it please the court, the counsel for the respondents in the case, Ambedkar Progressive Movement versus Union of Indiana. Your Lordship, I shall be acting as speaker number 1 and 2. Speaker number 1 shall be dealing with issue 1 and 2, while second speaker shall be dealing, I am the single speaker, but just for marking purposes, I shall be dealing with issue number 3 as a speaker number 2. The council seeks permission of the court to address the bench as your lordship and your ladyship respectively, and as your lordships collectively. Much obliged, your lordships. If your lordships are well versed with the facts of the case, council seeks permission to proceed with the orals. Your lordships, prior to moving forward with the submissions on the issues framed by the court, we would like to submit before this honorable court a preliminary objection to the maintainability. Your Lordship, we would like to submit the Honorable Supreme Court's case of PUC versus Union of India. Your Lordship, the PUCL case essentially distinguishes between the right to vote and the freedom to vote. The right to vote has been fundamentally categorized as a statutory right alone. It is not a fundamental right. Furthermore, if you may refer to the cases of Ramdas Athawale versus Union of India as well as Harbhajan Singh versus State of Haryana, it has been fairly stated by this Honorable Supreme Court that in instances where the fundamental right is not being violated or is not being contended, the same is not maintainable under Article 32. Hence, I would like, as a preliminary objection to the maintainability of this case, I would like to state that the same be dismissed on its preliminary itself. If your Lordships are satisfied, we would like to proceed with the issues paying respect to the restriction of this court. Much obliged, your Lordships. Your Lordship, issue number 1 is with regards to whether the impugned amendment acts is violative of the basic structure doctrine. Your Lordship, our argument shall be in 3 lines. Firstly, with regards to the fact that such an one nation, one election policy is not against any of the procedures mandated by the Constitution. Your Lordship, it is not a contention of the petitioners that any procedural mandate under Article 368 is being violated. It is already submitted by the petitioners that they do not want to conduct the same. Hence, we would like to say that every procedure under Article 368 is being followed. Furthermore, we would also like to state that the Impugned Amendment Acts actually furthers the essence of democracy as well as federalism, which shall be elaborated in our subsequent arguments. Furthermore, to add upon to the same, we would also like to state that the one nation, one election policy has enhanced and promotes administrative efficiency, reduces election expenditure, and ensures policy continuity. All of which shall be elaborated in the subsequent issues. Your Lordships, issue number 2 is with regards to whether the one nation, one election policy is violative of the federal and democratic principles of the Constitution. Our argument shall be on 3 lines. Firstly, the one nation, one election policy enhances the federal and democratic characteristics by ensuring stability and good governance. Secondly, the implementation is through the practice of pragmatic federalism. And lastly, the enactment is legal and constitutionally feasible. On our first ground, we would like to state the case of S.R. Bommai versus Union of India. Your Lordships, apologies. I would like to submit our compendium for references. It is a compilation of cases which shall be referred by the respondents.
What is the merit of this amendment? Not from this economic and other technicalities. What is the jurisprudence base of this amendment?
Your Lordship, the amendment has been enacted under the amending power of the Parliament under Article 368.
Okay.
We would like.
What is the merit of India? What is the merit of the authors of India? What is the merit of Indian democracy?
Indeed. Your Lordship, Ladyship, what we are trying to correct, the mischief that we are trying to correct through this Amendment Act is essentially the fact that due to the various elections that are happening throughout the country, the actual administration and the actual policy implementation is being stopped.
Then
This
what is wrong with the administration? Because election administrators are concurrently appointed for doing the election.
Indeed, Your Lordship.
It's secure. When he is a salaried person, what is wrong with conducting elections simultaneously or in any way?
Your Lordship, we are not contending that it shouldn't be simultaneous. We are actually in favor of the notion that it must be conducted simultaneously. In fact, I would like to state an example for this self.
No, my question is very precise. What you are expecting through this amendment? What is wrong with that? Is it meritorious for Indian democracy?
Indeed, Your Lordship. So what we are trying to say is that through this amendment, we are able to enhance the stability and good governance of our country.
How can you enhance stability? Because if the tenure of the parliament has grown simultaneously, all other things have grown. If a particular parliament party is representing any other 27 state or 28, out of 28, 27 state in India, they can withdraw. That collapse the entire democracy of India. Then the people are traveling for the power vote and for the constituency of the democracy.
Your Lordship,
It's a
so
chaos under the constitution.
indeed, Your Lordship. So what we are trying to say is that the stability is enhanced because one of the fundamental problems with the problem with the conduction of elections in a separate manner, as it was done prior to the Amendment Acts, was the fact that there was the imposition of MCCs, which are Model Code of Conduct. I would like the bench to...
This is not a legal document, it's only a guidelines issued by the Election Commission that can be referable. It's not a legal document, just like a recommendation of President or Indian Constitution.
Lordship, however, the same is being followed in order to help and protect the...
NCC says.
Your Lordship, if you may refer to page 4 to 6, my apologies, page 25 to 28 of the committee that is being presented, there is a Nidhi Aayog report that is being submitted, which actually elaborates on what the MCC says. Actually, during Lok Sabha elections,
Then
and
council, you have reported all these things. Then what is the merit of Indian Constitution? What is the merit of Indian democracy? As far as this amendment is concerned, they are spending so much of money, so much of time of the Indian Constitution, and it's a time of we people, because Indian Constitution is written in India. What is the merit of Indian Constitution? What is the merit of Indian democracy?
what is the benefit from this Amendment Act? Yes. Okay, Lordship, I would like to elaborate the same in 3 lines.
Yeah.
Firstly, on the fact that it enhances stability and good governance. One example for the same is the MCC.
Then how can you say that stability? Because the stability has gone.
Indeed. So, if you may refer to the report, what it actually says is that this report actually analyzes the 2014 Lok Sabha election, and in that year itself, there were 7 months the whole country was was put into suspension, which is specifically 3 months the whole country, 2 months Maharashtra and Jharkhand, 2 months Jammu and Kashmir and Haryana. During MCCs being implemented, no major development programs can be conducted, no major welfare schemes can be implemented. These are...
Council, this being the situation, India is the 4th largest economy in the world.
Indeed, Your Lordship. But what we are trying to do is that through this amendment, one of the major merits of this amendment is increasing from the 4th to the 1st, Your Lordship, through which we can actually stabilize our good governance and enhance our economy. Further,
2026 election is conducted. Thereafter, the parliament is dissolved after 2 or 3 years. Then another election will be held. Thereafter, the term of the parliament will be for the remaining term.
Indeed.
So there will be 3 elections. So the same thing happens.
Indeed, Your
Also,
Lordship.
in the same case, in the case of assembly also, that 5 years term will not be there, because after dissolving, you will get only the balance term. So that time, mode of conduct will apply, and the activities will be standstill. So how this will help you?
I understand your concern, Your Lordship. However, first thing for sure is that the mode of code of conduct must be reduced at its maximum. As you said,
That it is for you to decide.
well, even in the scenario that you have pointed,
It's not constitutional amendment is not lesser.
indeed, Your Lordship. However, MCC is required, as stated by the petitioner itself, MCC is required for protection of the people from any influence. The reason why MCC restricts any developmental activities should be implemented close to the election period is because such developments or such programs instituted by the government can influence the people. So one of the ideas that MCC actually brings out is that people are not being influenced. Hence, what we are trying to do is that we are reducing the implementation of MCC to the core minimum, which can be done only.
MCC is not a legal document, so therefore we think for the part of the office of the election commission. My question is, what is the merit of Indian Constitution? What is the merit of
Yes.
representation of representatives?
Indeed.
Speak legally.
Indeed.
Yeah, then it is
So,
okay, because in the simultaneous election, at least we have 3 elections. But for the implementation of this amendment act, we have umpteen number of elections. But one is this one, everything is another election. Then
indeed.
is it make any benefit to India?
Your Lordship, I would like to come back to the same question in a very structured manner.
Yeah.
First of all, the MCC, you said that it is not a legal document, but it is. I would like to say that it's one of the procedures that is followed by the Election Commission of India. That's one thing. Your Lordship, furthermore, if you may look into it, Your Lordship, the dissolution of states is a democratic accountability. We are not questioning how the state is being dissolved. However, even
Dissolution of state before the amendment is only permitted under the constitution as per article 174. Because of specific reason, the governor can dissolve the state legislative assembly no question. After this amendment, there is no fixity. That provision is also applicable now. There is double possibility now.
Your Lordship, no, Your Lordship, the dissolution of the state government is not being changed any so matter. We have,
Right, what is stated in Article 83?
Your Lordship, Article 83 is with regards to the term of the state government.
Then,
But
what is stated in Article 83 is, there is a resolution in case of Parliament, subsequently, all other 28, including the Union territories, will collapse. This is specifically mentioned. My question is, unless and until this amendment came into force, there is some constitutional fixity. Now, after the amendment, that constitutional fixity has gone, legally speaking.
Your Lordship, you might be talking about the Amendment Act, Article 83, just for clarification, right?
Yeah.
Your Lordship, if the Parliament dissolves before the full term,
Yeah.
as per amended Article 83, clause 4,
Yeah. What happened to state legislature assembly?
Your Lordship, nothing happens to the state legislature.
But it says, the state legislative assembly is constituted in any general election held after the appointed date shall come to an end on the expiry of the full term of the House of People.
Indeed, Your Lordships. However,
Once the House of People falls down or it completes, the state assembly also goes.
Your Lordship, I would like to
Go for the next election because it has to be done simultaneously.
Indeed, Your Lordship, I would like the court to be focusing on Article 83, clause 4. If the Parliament dissolves prior to the completion of its full term, the state assemblies are not dissolving. If you may refer, the Parliament shall elect an unexpired period. Your Lordships may.
You should well aware of the article of this amendment.
Indeed, Your Lordships, if I may read out for the benefit of the court, notwithstanding anything in Article 83, clause 2, where the House of People is dissolved sooner than the expiry of its full term, the next House of People constituted pursuant to elections occasioned by such dissolution, unless sooner dissolved, shall continue for such period as is equal to the unexpired term of the.
What I asked you, because that's why I said if election is conducted in 26, then the parliament is dissolved in the year 29. Thereafter, the next parliament will have only a period of 2 years.
Indeed, Your Lordship. So,
election should be held in 31 again, 29, then 31 again.
Indeed, Your Lordship. For the clarity, I would like.
Same thing happens in the case of assembly. Assemblies are dissolved midway, they will have only the remaining period. That is what, so in assembly also the election will be held in the year 2020, then thereafter in the year 2031.
Indeed.
So that model conduct will come into force every time.
Indeed, Your Lordship.
So how it will help you?
Indeed. Prior to answering that, sir, I'll just.
One more thing, as per the offense of my there is a relevant issue. If the legislative assembly have 4 years soon, then the question will raise, they are also collapsed. Then the re-election is not required.
Apologies.
This is the situation.
Apologies.
Upon the falling of the Lok Sabha, the House of People. That is what is envisaged in 82A2.
Yes, that is a full term Lok Sabha, Your Lordship.
Yes.
The falling of the under Article 83 is a half term, long term.
Please
So,
read 82A2.
yes, that is with regards to state assemblies shall dissolve when the full term of the parliament is completed. However, in Article 83, the dissolution of the parliament is not the completion of the full term, Your Lordships. That in such a dissolution, the parliament shall conduct a mid-term election. That does not affect the state legislative assemblies, Your Lordship. That is clarified under the Constitution Amendment Act.
Understood the law clearly, because if the tenure of the parliament is not finished, there are 2 years remaining.
Indeed.
Subsequently, that is also applicable to all the state. In case of that state, there are some difference. Some state are 2, some state are 3, some state are 4, some state are 1.
Indeed.
Then they are equally affected.
Indeed.
Then they will not complete their tenure.
Your
That
Lordship.
is fixed by the people of India.
Your
Through
Lordship.
the democratic process. That is why the democracy is affected.
Your Lordship. So once synchronization is done,
Yeah.
every parliament and every state has the same timeline.
Yeah.
So every 5 years, the general election will happen.
Yeah.
Now, if the parliament dissolves,
Comes in my genuine doubt is synchronization for the benefit of whom?
Your Lordships, I will be answering each of your questions one by one.
Yeah.
Please give me time. So, I would like to state that once the parliament dissolves, say for after 3 years, the state assemblies will be in motion. The continuing as per Article 84. The parliament shall go through a. After the parliament comes to a midterm election, the elected representatives shall be functioning for the remaining 2 years. Now, once the remaining 2 years is completed, the full term of the parliament is over. And once this full term is over, every single state and every single local authority is being dissolved. This, as synchronized, shall complete the full terms of the state assemblies automatically, your lordships, because they are synchronized in the first place. Now, your lordships, to answer your question, whether such midterm elections shall actually lead to multiple elections, which is counterproductive of the functioning or the basic essence of one nation, one election policy. Isn't that? So it is. Your question is whether it is counterproductive. Your lordship, I would like that. Even prior to the amendment acts, there were dissolutions in motion. If
after dissolution, they will get the full term.
indeed, that is one thing. However, if you may, I do concede to that fact. However, I would like to place reliance on this. I would like to place reliance on this honourable court's observations under State of Rajasthan versus Union of India. If you may refer to page 7 and 8, where it states that extent of federalism watered down by need of progress and development of the country, standing in the way of legitimate and comprehensive planned development of country in manner deviated by central government. Your lordship, in this honourable court in state that in cases where the progress and development of the country is being focused by the central government, the state coming in asking for contending the same cannot be this extent of federalism is seen in such a manner is what the state
Federalism should have a limit.
indeed, your lordship.
Too much of democracy, just like too much of democracy.
Indeed, lordship.
Federalism.
Indeed, lordship. However, this honourable court in multiple instances have actually elaborated on what is the scope of federalism. It is
They had a specific attention that this is something that strikes at the very root of the policy decisions and the policy implementation that the government will be able to take. Like for example in Kerala, if you look at the local elections here, the local elections to all the municipalities would happen at the same point of time. Municipality in Kerala, which conducts its elections separately, that is the municipality of Mattalu. And that has been permitted and followed. It was not felt necessary here, so as to see tenure of the Mattalu municipality should be cut short so as to make to the rest for the reason that we permitted to continue for a period of 5 years as has been elected by the people. So that is the way in which we have been following, looking at it as something sacrosanct, or at least something wherein the people as well as the legislators who have been elected have a legitimate expectation that they will continue for a period of 5 years, and they will get a period of 5 years so as to implement the policies.
indeed.
That is what is being
Indeed, your lordship. I would like to state this in 2 lines. Firstly, on the fact that this.
One more thing. As per your submission here, what you submitted here is in India, the constitution is a living document. We don't have any federalism as the real state. We are only cooperating federalism.
Indeed. Your lordship, I shall answer again in one by one. Firstly, to answer your lordship's question, I would like to state that first.
Policy decision. I was a policy decision. Policy implementations, which are favorably benefited by 5 years.
In your lordship. So, I would like to state that the one nation, one election policy doesn't actually deny the expectation of the people of India. When they vote for the certain body, they are expecting 5 years of completion. And this is not being denied here, lordship. Because when midterm elections are being conducted, the people are very much aware that such government body shall only function for the remaining period. So the people can actually analyze as to what all promises can be fulfilled through these Your lordship, hence I would like to say that
With such requirements, so that's foresighted-ness and far-sightedness is a question that they would conduct.
Your lordship, I shall be elaborating the same in the subsequent, but just to brief it.
If he goes to vote, he has to look at the fact that this is only going to be a tenure of 3 years.
Your lordship,
And vote according to that. That is something that is we are expecting much from the Indian voter today.
in your lordship. And furthermore, the petitions have stated that free and fair election is actually a basic structure of this constitution. And hence, this respondents actually taken the responsibility that we must actually take every measure necessary to actually protect the people from any influence. So, and
that takes us to their convention, that
Indeed.
autocracy. They had a convention, even though we didn't appreciate it. Don't you think that before the election, whatever issues happens just prior to the election have a big influence on the election as such? So, if something is happening just prior to the election so as to influence the voters, then that would have a rippling effect all through the Lok Sabha, the Assembly, as well as the municipal elections.
indeed, your lordship.
So that is something that they, maybe, even though they didn't say that, that is what they would say as autocratic. Something that would lead to autocracy. May not be autocracy as such, but a situation where this temporary incidents going to influence and who should rule for the next 5 years, not only in the parliament, but also in the assembly as well as the municipal elections. So that is the element of what is the point of, as I understand.
As far as strengthening the democracy in India, we have more than 2,000 small political parties in democracy. But most of these namesake parties are vanished.
Indeed.
Because declining of amendment. And some of the prominent political parties will suffer. Because they are not in a situation of competition. Because in Kerala, we have so many political parties. So they simply included can consider a political party. They can represent the parliament before this happens. That is strengthening democracy. My voice is at the parliament. But now these things are narrowed down. It's a process of killing of democracy.
Your lordship, I would like to say this by saying that, first of all, synchronized elections does have a historical backing. And up till 1967, synchronized elections was there. Even today, certain state assemblies do, even today as in prior to the Amendment Acts, until the last elections that happened, there was instances with state assemblies as well as Lok Sabha elections did happen in the same time, simultaneously. Your lordship, I would like to come back to my maintainability part, stating that their prayer of just
Even after 67, there was attempts to make this synchronized election. For
Indeed.
example, when the Prime Minister passed away and immediately an election was conducted, there was a situation where one party obtained the highest number of votes. What they did that immediately after coming into power is to dissolve all the other assemblies and conduct an election
Indeed.
only for the purpose of reaping benefit of that incident.
Indeed,
And
yeah.
it worked also.
Sorry?
It worked also. It did work. So, even after 67, attempts towards synchronization and to reap benefits of such synchronization have been done.
Yes, your lordship. However, I would like to state that, coming back to my argument, stating that the petitioners have contended to the fact that if we do conduct the national elections as well as the state local elections together, as the ladyship has pointed out, this might give an undeniable advantage to the national parties. However, I would like to I would like to stand in the contrary, stating that if the petitions are actually conducting the same, why wouldn't they not pray for an instance where simultaneous elections shouldn't be conducted anywhere? Here, the only prayer or relief that is being asked by the petitioners is that the one nation, one election policy be struck down. However, even without the one nation, one election policy, there where certain states have the Lok Sabha elections as well as the state assembly elections together. In such cases, even in such cases, the National Assembly does have.
Concept, they are not arguing like that. They are the constitution validity of this amendment. They are not arguing for the policy. Then as far as this amendment is concerned, that is affecting the federalism as the basis of the Indian constitution. It is one of the arguments.
Indeed. Your Lordship, if you may refer to the contentions under the three of the petitioners, they have clearly cited, cited the fact that national parties does have an advantage. Even your ladyship did pose me a question whether the same shall lead to killing of state parties and local parties. However, if that was the case, I would like to point out the lack of bona fide intention of the petitioners, where they are just praying for the striking down of the constitutional amendments. Because if that was the case, if national parties does have an advantage, why are the petitioners not asking an instance where There shall be no instance where the Lok Sabha and the state assemblies are being conducted together.
It's a question of their argument. You're asking some legal question to you. What is the benefit of the constitutional benefit of this amendment?
Indeed, coming back to the question that we posed again, the merit of this amendment.
Any question? You have to answer what is the constitutional benefit. If it is economic, it's economic is
Mm.
not technical because the election is also done nowadays by spending money.
Indeed.
Because India is a largest commission, election is more expensive. Then economic is not a legal issue.
Indeed.
It's only a technical issue.
Indeed.
What is the constitutional benefit of this amendment?
The constitutional benefit would be enabling and enhancing strict governance and good governance. Secondly, the fact that this shall actually enhance the federal character of the constitution as observed in
On which
government.
way? On which way?
Yes, as observed in the government of NCT Delhi versus Union of India. Your Lordships, if you may refer to.
That case is entirely different. That is different.
Indeed, it is entirely different. However, in this Supreme Court judgment, they actually touch upon what is the nature of federalism that India is following. And in this nature of federalism, the Supreme Court has actually stated to the fact that India's federalism is not in its purest nature. We should also consider the same to be a pragmatic federalism. Your Lordships, we can say that pragmatic federalism, as stated by this Honorable Court, can be practiced for achieving constitutional goals by leaning on the principle of practicality. Your Lordships, through the synchronized elections, what we are trying to do is the most practical approach to enhance good governance and stability. Furthermore, another benefit of the Amendment Acts would be the fact that this actually enhances one's freedom to vote by actually.
It's a relevant question. What was the constitution compulsion to make this amendment in India? What was the social compulsion, economic compulsion? There are so many compulsions.
Indeed, Your Lordship.
What was the social necessity? Because it's more expensive. Because Indian constitution, the king is the people of India. Then how this amendment is making use of law?
Indeed, Your
What
Lordship.
was the social
I would like to refer to the Parliament Standing Committee report, 79 Parliament Standing Report, the last page of the compendium, which actually lists down what were the reasons. This includes cost effectiveness. This includes reducing the implementation of MCCs, which stagnates the.
Two arguments are baseless because as per the Law Commission report 2018, they were added that there will not be any substantive change with respect to the economic capacity and other things which are only technical issues. Then it is clearly stated under the Law Commission report of 2018.
Your Lordship, I do not have access to the Law Commission report. However, I would like to state that
Then
even if it's not.
economy and other things, convenience and other
Indeed, that are
these
actually
are
given.
administrative matters. What is the jurisprudential benefit?
Yes,
of-
judicial jurisprudence, or if you are focusing on the law itself, you can say that first and foremost, it enhances a person's right to vote.
Then why to vote is similar? What happens? What is the difference of right to vote? Now it is electronic machine.
Indeed, Your Lordship. So, first of all, I would like to ask for apologies for actually deviating from my point. So, I would like to say that it is not the right to vote, but rather the freedom to vote. As started through my oral submission, I stated that.
The freedom.
Indeed. So, right to vote would be yes, just if you are 18 years, if you are in the electoral roll, you can go and vote. However, a freedom to vote would be the fact that you do have access to voting.
Is there any change relating to any of the provisions of the presentation of people?
Indeed not. Right to vote is a statutory right. That I agree. We are not touching upon the Representation of People's Act. We do not even intend to touch the Representation Act. We do respect its validity. However, what we are trying to do is that through these amendment acts, the freedom to vote is being enhanced by two reasons. Your Lordship, first thing is that it enables higher voter participation. The simple convenience of the people.
How it is?
Indeed, the simple convenience of the people to go to the voting booth and vote on every single legislative
Is there
body.
any statics? As per the statics of Election Commission of India, the percentage of voting is increasing, particularly in Kerala. Even educated
Indeed.
people are not participating in any democratic process.
Indeed, Your Lordship.
If
That
you have any statics, then how we can argue based on some of your concept and some of your speculations?
Indeed, Your Lordship. So, though I do not have statistics, what I would like to say is that if, as people like the young population, if they are not actually coming forward to vote. What could be a convenience for them is that them being able to exercise their right to vote in the Lok Sabha, in the state assembly altogether, which would actually be an incentive for them to go and exercise their vote every time, every 5 years, rather than going every year and come.
For that convenience, you are constituting a big parliamentary committee and a
Indeed, indeed, Your Lordship. This certain convenience actually enhances a person's freedom to vote, which has been laid down by the PUCL as a basic structure doctrine, as well as the fact that it is an extension, as pointed out by the petitioners, it is an extension of the Article 19(1)(a). Just to add on. Furthermore,
Now the issues that will be arising in the parliament election, state assembly election, and panchayat and municipal election, will be entirely different.
indeed,
So now the voters will be confused. They will not be able to comprehend all these materials and vote in a fair way. That is one of the conventions.
Your Lordship,
Especially the literacy rate in India, very low compared to other countries.
indeed, Your Lordship. I would like to say that this technicality can be enhanced in. I have actually two contentions for the same. First thing is that if you are actually synchronizing the elections, the resource and the ability for voter awareness, conduction by the government for voter awareness can be further easier, because we can concentrate resources on a single period and actually enhance voter awareness. That is one thing. Furthermore, I would also like to state that even prior to the implementation of the amendment acts, as previously stated by me, there were instances where in a particular state, the state assembly as well as the Lok Sabha assembly had simultaneous elections. In such cases, if it is not proven that the national parties did have an advantage over state parties. So the contention of the petitioner saying that the national parties shall have an advantage, I don't. The respondents would like to beg to differ to such a contention, Your Lordships. If Your Lordships are satisfied with the submissions, I would also like to point out furthermore on the fact that simultaneous elections also enable better mobilization of resources to facilitate voter participations. The election commission and their administrative bodies would be able to channel their efforts more efficiently, ensuring availability of adequate polling stations. Your Lordships, all the more what the respondent is trying to contend is that.
Then how can you say that that is more, that's spending more money from the state exchequer and it's creating more economic burden on the state because there is no certainty for any of the democratic bodies that at any time election may come. Even the 2024 Indian government is a coalition government. At any time it may move. Subsequently that will affect the entire state. And how can you say that what is the certainty of Indian constitution?
Your Lordship, this single question itself is actually clear of its answer, that such a certainty never, if you do.
Before this amendment, there is a certainty. Only possibility with regard to Article 174 and 85. That is a procedural mechanism of Indian Constitution because of a specific reason, which is provided the power is vested to the executive authority. That is for the president and the governor. Under Article 356, there is specific reason. The Constitution guidelines are there. Nobody can do it.
Indeed.
There is ensuring the democracy of India. After the amendment, entire things are baseless. That's why I'm asking the question. I think the council is aware of all these things. But
Your Lordship, so I would like to say that this full term 5-year period, even prior to the amendment, was nothing sacrosanct, as pointed out by this
no,
honorable court.
then what is the problem with respect to Article 174 and Article 85? And what's the problem with respect to emergency provision under the Indian Constitution? There are some specific constitutional
Indeed, Your Lordship. So
even
even
the president
in
doesn't have any discretionary power.
Your Lordship, so even in 174 and 83, what we can actually understand is the fact that the
Not 84, 85.
185
Resolution of Parliament and the resolution of State Legislative Assembly.
for
The power is vested to the President and the Governor of the state. For
This-
the resolution of State Legislative Assembly and the resolution of Parliament, there are some specific reasons. There is no question of any simultaneous.
Your Lordship, could you please repeat the article number?
Article 85 and Article 174.
Indeed, Your Lordship. So, Your Lordship, 174 is with regards to
constitution of state legislative assembly.
Sessions of the state legislature resolution. Your Lordship, this specific 174 article as well as the specific 85 article, 85, right? Your Lordship, apologies, Your Lordship, but these specific articles have not been amended. The dissolution of the state legislature as well as the parliament
No, it's
can.
not amended, but this amendment is affecting the double possibility that is creating double possibility of the Indian constitution.
Your Lordship, so there is only one point to which the resolution can happen, which is the parliament completing its full term. As already elaborated, I would like to say that once it is synchronized, the full term of the parliament is automatically the full term of the state legislature. So such a dissolution is a certainty under even is not being affect the provisions of Article 85 as well as Article 174 is not being amended or affected in any such manner. And even after the amendment acts, I can assure you to the fact that unless the state or the Lok Sabha completes its full term, the only manner in which the state government or the parliament can be dissolved is as per the provisions of Article 85 and 174.
What about these law conference motions that we usually cover?
Indeed. The law conference motions,
Law conference motions can be brought at any point of time.
indeed,
And the government can be brought up.
indeed. Yes, in addition to law conference motions, which is actually a democratic practice of democratic accountability of the representatives of people, which
After this law conference motion, along with this, now we would require a conference motion that we are ready to form the government. If that is not there, and if the government falls down, then what happens?
Lordship,
Then do an election.
I would like to beg to differ of a conference motion being implemented. There is actually no conference motions to my knowledge. However, post the non-conference motion, which is an exercise of democratic accountability, what the people is able to do is choose the state legislature or the parliament for the remaining period, and they can exercise they can further their governance or policy measures. Your Lordship, I would like to conclude my arguments by stating
Do
that
you agree that democracy is one of the basic features of Indian constitution?
indeed,
So they contended that democracy cannot be compromised for the sake of administrative convenience. What is your
Indeed.
argument on that?
Your Lordship, I would stand with the same. However, what my contention is that the amendment acts are actually enhancing the democratic features, Your Lordship. Because democracy is also including the participation of the people. And as already stated, through the synchronization of elections, actually the convenience aspect and the accessibility to vote is being enhanced, which in turn actually enhances the democracy in our country. If your Lordships are well satisfied with my submissions, Council seeks permission to proceed with the prayer. Wherefore, in the light of the arguments advanced, issues raised and authorities cited, the Council for the respondent humbly pray before this honourable court that it may be pleased to dismiss the petition and order any relief as this court may feel fit for in the light of justice, equity and good conscience, humbly submitted before this honourable court. In this case here, it was an honour arguing before this court. Much obliged, Your Lordship.
Council would like to start the
Only one council is going.
Yes, yes. Council one, Speaker one will be only doing the rebuttal. Your Lordship, it's very important to understand the fact that if like any of these constitutional amendment has been done, before going to like administrative convenience cost, it's very important, and like I'll be giving five questions that I'll be posing is the fact that Your Lordship, first and the most concern is the fact that Your Lordship, right now there have been different tenure of state assemblies being done, panchayats, municipalities being done. In order to start this particular thing, one nation, one election, what the council contended, and my learned brother didn't respond to that particular query. And one of the most fundamental flaw in this particular thing is the fact that in terms of aligning all these things, when it comes to union, state, and the local bodies, there need to be either like premature dissolution of assemblies or something.
Even now, they contended, even now, at present, there are elections simultaneously held because the parliament and some of the state assemblies elections are held together.
In
So, what is your
Indeed, I'll come to that particular thing as well, that particular query as well, Your Lordship. So basically, what the council is contending is the fact that in terms of synchronizing all these elections, Your Lordship, there need to be either premature dissolution of the state assemblies or something, or their 5-year tenure need to be extended. And Your Lordship, both of these things the Parliament cannot do it, Your Lordship.
They would do it batch by batch. That it would be done in a single stroke. As regards you are concerned about how this one nation, one election program would be kicked off.
Indeed.
And at the point of kicking it off, there would be requirements so as to cut short the tenures of some of these assemblies as well as municipalities. That they propose to do it in batches.
Your
So
Lord,
it's not as if that it would be done in a single stroke.
but Your Lordship, how the Parliament doesn't have that power to dictate the tenure of a government that has been elected by the people itself. How can a Parliament dictate the tenure, like either premature dissolve the House or the extent of the 5 years?
That's fixed at present in 5 years. Yes. So similarly, the Parliament can fix it. You say that the Parliament does not have the power to fix it.
Your Lordship, then the basic essence of the preamble, like we say, like Indiana is a democratic country where the government is being elected by the people, then how come the Parliament can dictate the tenure of the state assembly on?
Here, the agreement was not passed after the debate. It was with the ratification of the state. There is a physical compliance of the rules are there.
Indeed, Your Lordship.
So it's a rejection as per the constitution mandate.
Your Lordship, but 50% ratification of the state cannot be interpreted as the state has given the
No, I
consent.
can say that because it's a constitutional mandate.
Your Lordship, this is the constitutional mandate. The council is not at all arguing on the fact that due process of that's been followed. That's mentioned in the clarification
Then
itself.
how can you say
But-
that it is endless of federalism because they have complied all the constitution formalities as per Article 68.
Yeah.
Because it's a matter of concern of basic structure of Indian constitution.
Indeed. Your Lordship, the procedure has been followed, no question on that. But Your Lordship, can the Parliament, in terms of implementing this, there's no provision in the Constitution which says that the Parliament has the power to
The
dictate.
council, if a decision has taken with the participation of the affected parties, how you can say that it is something against the federalism?
Your Lordship, 50% ratification cannot be interpreted as the
You
state.
can say that because the constitution is supreme in India.
That's the mandate of the constitution.
Indeed, yes, Your Lordship, but the problem with this particular thing is like 50% ratification cannot be interpreted as the state giving
That's what
consent.
the constitution says.
Indeed, yes, but that.
You cannot go beyond that. You cannot say that 50% is not something that would properly disclose what is in the minds of the state legislators.
Your Lordship,
The constitution says that 50% is enough.
indeed, yes,
That
Your
is the cutoff that has been fixed by the constitution. And as long as that is complied with, that is a satisfactory compliance with the mandates.
Your Lordship, but that 50%, because for implementing it, either like what the council state emergency need to be introduced in order to cut short the tenure of the state assembly.
The council, that argument would not be sustainable because as a council, you don't have any power to review the constitution. Court is stated the constitution as specifically compliant. That is why the president has consulted this amendment. No, there is no question of any federalism in that aspect.
Indeed, yes, Your Lordship, that is what is mentioned in the case of Keshwananda Bharti. Even the due process has been followed under 368, but still, if it's violation with the basic structure, that could be done, Your Lordship.
What is damning the legality of Article 368?
Your Lordship.
Respect to the amendment.
Your Lordship, this particular essence only, how can the state legislative, and even what's the Lordship pointed out that there are technically 4 states which run simultaneous election with the union. Your Lordship, that particular situation cannot be related with this particular, like post-amendment to this particular thing, because of the fact that that 4th state does not have a concept of midterm election, which is to say, if any of the state assembly dissolve and then election is being done for 5 years, then the chain breaks. And that is technically what has, if Your Lordship may extend 2 minutes time, Your Lordship. Which is to say, Your Lordship, that was if like the state, and that is what happened like post 1967, and this was untouched because of the fact that 5 years tenure is an essential part. Your Lordship, my brother is being relating with the concept at that particular time there was no concept of midterm election. If like even like 4 state, like any of the house of like state assembly dissolved, that's done. Then 5-year tenure will be done, the chain is broken. But here what has been done, there is a rigid form of the government where the residually this midterm election is being done, and it will have like serious consequences, Your Lordship. No government will come up with all these policies, welfare policies and all. And even Your Lordship, can, when Your Lordship, this particular
Council, in case of repeated election, the people can choose more qualified person. It's an opportunity for you.
that's
Because it's an opportunity for you because as per the constitution mandate, once a person is selected, if that person is a corrupt person or a worse person, you don't have any opportunity. Then there is another opportunity, you can take another positive decision for the welfare of the country and you can change that person.
Indeed, not your lordship. What this will basically hinder the welfare. Like none of the state coming power for like 1 year will think about the long-term objective. And additionally, your lordship, the concern is even this particular amendment synchronizes with the panchayat and the municipality, which the council mentions in Schedule 10. It's the state legislature, it's a matter in state list entry file to state government to adjudicate when it comes to election of the local bodies. But in this particular case, the parliament has taken that particular power and in terms of synchronizing this particular election. Your lordship, but the fact is that, your lordship, the autonomy of the state. Your lordship, but
as per the council, as per the constitution have the power even to delimit the state election also. Delimitation of constituencies, which is done under the state election commission or the state land and revenue department as per the constitution mandate. It is exclusively under the control of the Indian constitution.
Indeed.
The constitution provided a specific scheme for delimitation of constituencies.
Indeed.
State government doesn't have any power.
Indeed. Your lordship, this basically takes the autonomy of the state and this is clearly against the
How can you say that it's autonomy of the state, because the constitution always, before this amendment, the constitution has given the specific guidelines for delimitation of constituency, which is the first state of election policy. That is why the state of Tamil Nadu objected.
Your lordship, that's being objected, like the delimitation. What the council is stating is the fact that, if like 1 minute. And is the fact that, your lordship, this particular act takes the autonomy. Even in SR Bombay versus Union of India, it was mentioned that the autonomy of the state in terms of adjudicating. Because in concurrent list, if there has been difference in opinion, difference in law with union and the state, then the union will prevail. But state subject matter are specific for the state and the parliament cannot adjudicate it. And your lordship, coming to the concern of cost, your lordship, cost is really not a big concern for a country like Indiana, your lordship. And even if that was the intent, they should have put a cap on the campaigning of the party itself, rather than putting a cost on conducting the election. And additionally, your lordship, the contention of MCC was imposed, your lordship. That happens once there is like technically, what happens in once there is election in the central government union level, then MCC is imposed in all over the country. When it imposes on a particular, when any state government, state election happen, it impose on that particular state. So that is not really a big concern. But even if that is a concern for the parliament, they should amend it. They should have like reduced the tenure of MCC rather than amending the constitution itself.
The majority of the Indian parliament can take any decision, because that is the power vested by the democracy and election role vested by the people of India. They can discuss anything, and through the majority, through the specific procedure of Indian constitution, they can pass any amendment act. What's the role of you and me to this amendment?
Your lordship, the constitution is the last resort if there is no resort. MCC, if policy is such a concern.
It's only a guideline, so it doesn't have any status of
Indeed.
law. But as far as the Constitution Amendment Act is concerned, it is as per the mandate of Indian Constitution. You and me cannot do anything.
But your lordship, if that was such a big concern, your lordship, then they should have ideally amended the MCC rather than touching the constitution, your lordship. Because this is one of the most sacred documents, your lordship. Rather than before coming to this particular, if you have any alternative, you should have.
It's sacred, but it's not legal. It's only guidelines of Election Commission of India. They have so many guidelines.
Indeed. That is what the council contention is. If they should have reduced the MCC duration itself, your lordship. That's it. These are like the 5 fundamental questions.
Your lordship, as per Rule 13.4 of the competition, my answers shall be limited to the questions that are posed during some reports. Your lordship, with respect to premature dissolution of the state assembly, I would like to plead for the attention of this court to provisions of Article 82A, Clause 1 and Clause 2. Your lordships, in these clauses, it is stated that the President of India may by notification issued on the date of the first sitting of the House of People after a general election, bring into force the provision of this article, and that date of notification shall be called the appointed date. Secondly, that is second clause, notwithstanding anything in Article 83 and 172, all the state legislative assemblies constituted, any general election held after the appointed date shall come into an end by the expiry of full term of the House of People. Your Lordship, so what effectively shall happen post the implementation of the appointed date is that the coming up Lok Sabha elections is not a simultaneous election. It shall be normal election. Once the Lok Sabha elections is completed,
What is the technical term in front of the simultaneous election?
indeed, simultaneous elections shall be gradually implemented. The coming up Lok Sabha
What
election.
is the meaning of appointment as per from your interpretation?
Apologies, Lordship.
Appointment date of.
Your Lordship, the appointment date as stated under Article 82A, subclause 1 should be understood as the starting period of the synchronization. Your Lordship, so once a Lok Sabha has been constituted, the President shall notify and the so-called appointment date.
So,
After the same, what happens is that any election that is after this appointment date shall be restricted to the completion upon the full term of the Parliament. So no.
only a technical procedure.
Indeed, Your Lordship, this technical procedure allows or ensures the fact that no premature dissolution shall be happening. So even if an election happens after the appointment date, the voters are well aware of the fact that
What
such.
is wrong with that? That is a concept of separation of powers, which is the basic structure of Indian Constitution, and the Constitution is also protected under this provision also.
Under which
So
provision?
it's a matter of concern of separation of power, executive power for fixing the appointment date.
Indeed, Your Lordship.
Yeah, why?
However, I beg to differ. The petitioners have stated that even if the appointment date is not being implemented, it is.
Who is implementing that? The President of India.
Yes, indeed.
It's only an executive function.
Indeed.
The separation of power is protected under the Indian Constitution as a
Yeah.
basic structure.
Indeed, Your Lordship. But it is not upon the discretion of the President to when to
No,
put
it's
this.
not a discretion, it's a constitutional mandate.
Yes.
Yeah.
So,
What is wrong with that?
Your Lordship, I am not telling it's wrong with that. I as a respondent, am actually saying that there is no premature dissolution as conducted by the petitioners. Once the appointment date is.
Once a tenure is fixed for 5 years, in any date it can be nominated called as premature. Because that fixity is governed by the Constitution earlier.
Your Lordship, there is nowhere it is stated that it is a tenure for 5 years. The same has been replaced by the term full term. So, after the appointment date being notified, any election that happens shall happen for the remaining period of the full term of the Parliament. So here, no one is dissolving for the synchronization, no one is prematurely dissolving the elected legislative body for the synchronization of elections.
You can say that it's a premature dissolution. Because not completing the tenure which is fixed by the Constitution. Why not?
Your Lordship, the Constitution doesn't fix any fixed tenure.
Why?
Your Lordship,
Because there is, given the Amendment Act itself, there specifically says that under Article 172, there is a specific scheme for fixing of tenure of the state legislative assembly. Under Article 82, there is tenure of the Congress also.
Your Lordship, Article 82 is that.
This Amendment Act, the Constitution also fixes this fixity of tenure of the Parliament and legislative assembly.
Your Lordship, the 5-year period
The
that.
Council is well aware of all these things because this is the basic concept of Indian Constitution.
Indeed, Your Lordship. Your Lordship.
And the legislative assembly is about five. It's a common information which is given by the Constitution.
They are appreciative that it says it's the date of dissolution and 5 years from the date appointed for its first meeting shall be referred to as its unexpired term.
Indeed.
What if he doesn't call for the first meeting?
Your Lordships, Your Lordship, I don't understand the same, but I would humbly plead before this court to actually believe in the functioning of a government.
All of the seats.
Furthermore, I would like to add,
Not calling for the first meeting.
Your Lordship,
So only technical information are
Yes.
given.
So it is
It's
from the
only
first
legal
meeting.
sustainability. So
So if there is an autocrat going to come and he doesn't voting, then this appointed date never happens.
Your Lordship,
So the date from which it shall be calculated never starts off.
Your Lordship, the calling of the first meeting is not upon the discretion. Your Lordship, I shall sum up in just 2 minutes. Your Lordship, the discretion of the President, but however it shall be under the accommodations of the people elected. So, Your Lordship, the same being, President even being an autocrat, is obliged to call for the first meeting under the recommendations of the people elected. the contention of the petitioners having that it cannot be considered with. Yes, one of the reasoning that has been put forward.
Period has been fixed within which this appointed date has to go, or the first meeting has to be started off. That may be the apprehension that they have. For example, with respect to the appointment of judges, it is referred to the government. No time period has been fixed within which they have to respond. So it remains there for years together.
Indeed, Your
Why
Lordship.
can't such a contingency be expected or apprehended here also?
However, Your Lordship, the calling of the first
We have
meeting.
to send the granting of consent to the bills passed by the Parliament of the Assembly.
Indeed,
If they keep it there, there is no time limit.
I understand.
Matters pending before.
I understand the concern, Your Lordship. However, I would like to move on to the second contention that is stated, which was
Cost regarding cost.
Your,
Expenses.
Your Lordship, the petitioner stated that the cost expenses is something that shouldn't be valued. We are just stating that this is an additional bonus to the implementation. We are not fundamentally basing our implementation of the Amendment Acts on the basis that it is cost effective. Furthermore, moving on to one of the other arguments that has been put forward by the petitioners is that the reasons that I did state on the fact that during my oral submissions, I did state that even prior to the implementation of the One Nation, One Election policy, there have been instances where state elections and legislative elections shall be were conducted together. Your Lordship, this was just used. Your Lordship, the petitioner, this cannot be read into the same context. But however, this example was used for the simple reason that I was just pointing towards the court that even in these instances, national parties and state parties are contending for the election together. And if they were to contend that the national parties do hold an advantage, the same must be conducted even prior to the One Nation, One Election policy. And I was only trying to point out to the lack of bona fide interest in which the petitioners have come before this court.
We don't interpret or we don't look into constitutional amendments from the short-term point of view. We look at it from a long-term point of view as to how it would endure on the Republic for maybe 50 or 100 years to come.
Indeed, Your Lordship.
So, what we stand that the national parties and the regional parties have taken at this point of time does not impact us when it comes to constitutional protection.
Indeed, Your Lordship. However, I would like to state that the state, through the advantage of synchronized elections, shall have the concentrated resources available for enhancing the awareness of the voters. We shall. Further, moving on, we would also like to state the fact that the petitioners have pointed out that under state list entry 5, it is the power of the state to legislate on matters of elections of local bodies. However, if you may read entry 5, it is specific. Just a minute, Your Lordships. Your Lordships, entry 5 is with regards to law, constitution and powers of municipal corporations. Your Lordship, I would like to clarify that the Amendment Acts do not touch upon the constitutional powers of the municipality or the panchayat. All that we are trying to do is line up their election dates. That's all, Your Lordship.
What is our jurisprudence to look into this matter, because it's a matter of state list.
Indeed, Your Lordship.
Constitutions streamlined as it's a matter of state.
Your Lordship, the state it specifies that under entry 5, local government, that is to say, the constitution and powers of municipal corporations.
Constitution is what? Constitution
It-
is what?
it- Your constitution means the.
Leading to it is by election that they are constituted.
Your Lordship, election provisions are very different. Constitution means who will constitute the local authority.
Constitution of the creation of.
In your Lordship, however, I would also like to point out the case of Kuldeep Nair versus Union of India. If you may refer to page 15 and 16 of the Comepetition, which says that the competence of the Parliament in shaping electoral processes, provides such measures do not undermine the democratic ethos of the Constitution, is valid. Your Lordships, we are just contending that we are actually enhancing the democratic and basic features of the Constitution, and hence these provisions must be followed. That's all, Your Lordships.
So as regards the performance, both sides have performed well. I congratulate both teams for the substantial job that they have given and also the excellent performance that have been put forth. Winning and losing doesn't mean much. It matters as to how good you have participated, and both of you can rest assured that both teams can rest assured put up a very good show, practiced well, and worked up very well. Anyway, because however good the performance is, we may be able to improve it at some aspect or another. As regards Moot propositions are concerned, many times the idea that a problem setter would have in his mind is to prod and make the students think and also go beyond what has been specifically stated or mentioned in the proposition. So judges essentially look at not what is there or how you answer to the questions correctly or not, but how you have worked on it. Have it made you think on it? Are you innovating on it? Is there a critical analysis of the subject matter? These are the aspects that would be primarily that would be looked for. Of course, advocacy and skills like that, how the responding to the questions would come in. But the kind of approach that you have taken to the Moot problem, whether you have tried to improve it, whether you have tried to work on it or extend it to venues and areas that would squarely go beyond what is there. Like for example, this is not a problem that I think could be confined to any particular fundamental rights. It might have various facets. How you have identified the facets is what we would be looking into. I would say that both of the teams have worked well. Congratulations. And the rest will follow. Now I leave it to my brother.
Congratulations to both the teams. You have worked very well. And response to the questions were also very good. Usually in the court, when the judges put questions to us, we get a bit trouble. But as far as we could notice, you were very cool in making and answering all our questions. Very, very commendable. And with the experience that you gain in the coming times, I'm sure that all of you can come up very high in this profession. Congratulations to both of you. The winning and losing, don't take it as seriously. That's all part of these competitions. Anyway, it was very difficult for us also to choose between you because both the teams were very good.
Congratulations for all the participants because you have the confidence, courage, and communicative skill. Everything is here, but it's not a job of media. Then what you are communicated, you should stick on the law. Law is an armory of a lawyer. So in the moot court, these things are more decorative, but in the court, what you are drafted, what you are presented based on some content, that should be legally focused. Otherwise, all the things are very lectures. Then, as far as a teacher is concerned, they can lecture in any way. But as a lawyer is concerned, they should be very precise to come to a particular law point. Ultimately, the law point will save you, rather than any other. So you find a solution for this under the constitution or any standard, then stick on that from the beginning to end, not reach up. Then there must be some legal basis. You are standing on the foot of law, not on the fact. So I think that is the problem you are facing, this somewhat problem. As you pointed out, because of the technicality of this problem, you will not be in a position to focus the law. Otherwise, very fantastic, marvelous presentation from such a young law students. It's you are a beginner. You can travel your own distance. You will be the future lawyering fraternity of India, which you all of us to become a great judge of the Supreme Court of India or a very famous lawyer. Wish you all the best.
The final rounds are over. I request the participants and the guests to move on to the admin block. We'll have the valedictory ceremony there, and please also arrange for everyone.